Hi, very good morning. This is again a Supreme Court judgment under the Customs Act. Citation is Suraj Impex India Private Limited versus Union of India. Issue before the Supreme Court was whether board circular issued by Central Board of Excise and Customs, now CBEC, whether board circular was prospective or retrospective. How to determine that? That was the question before the Supreme Court. Facts of the case, I am cutting down many things. I am not mentioning the notifications. I am not going to give the circular number because understanding the principle is more important for than looking at to the into the more detailed notifications and circular numbers, etc. Because this case is filed in 2016, so 9 years over. So facts of the case: appellant was a merchant exporter. He was entitled to claim duty drawback at all industry rate. The schedule to the notification permitted 1% duty drawback on exports, whether Senate credit was availed or not. Till 2008, appellant did not have any problem. He received duty drawback correctly. Then Director General of Central Excise, he put spokes on that wheel. He formed an opinion stating that the manufacturers or exporters who have availed the rebate of Central Excise duty under the Central Excise rules. I am not giving the rules. Under the Central Excise rules, he is not eligible to claim duty drawback. So on that basis, he withheld the duty drawback. The merchant exporters approached the board with a representation on the ground that duty drawback is given under the Customs Act, whereas benefit of rebate was granted under the Central Excise Act. So both are totally different. CBEC agreed with the merchant exporters and issued a clarification that both duty rebate under the Excise Act and duty drawback under the Customs Act can be claimed. So department accepted their representation. This circular was issued on 17/9/2010. Then based on that circular, the appellant went to the department and claimed duty drawback. Now circular has been issued, please give me the duty drawback. Department said, circular is issued correct, it is in your favor, but it is effective from 29/2010. It specifically says this circular will be effective from 29/2010. So they said for the previous years you don't claim, we won't grant you. For the years following 29/2010, we will give you the benefit. That is what they said. They said, in effect, that this circular will be effective prospectively and not retrospectively. On that ground, again they denied the duty drawback. Appellant challenged this by way of a writ petition before the High Court. High Court accepted the contention of the department and dismissed the writ petition. Then again SLP was filed before the Supreme Court. Supreme Court said to decide whether a circular is prospective or retrospective, the substance of the circular is more important than the form. So just don't see what is stated. Substance is more important than the form. Supreme Court noted the following aspects. 1. Circular was issued after representation from merchant exporters. 2. Reading of the circular and notifications showed that there was no express distinction in the benefit accrued to the merchant exporters from day one. From day one, the same thing has been granted. 3. Circular does not vest any new rights to the merchant exporter or a new burden on the department. That is 3. 4. The language of the circular did not expand or alter the scope of the notification but cements the claim of the exporters. 5. The words used in the circular within quote shall be deemed always to have meant close quote, and again open quote, shall be deemed never to have included close quote. These words, they are declaratory and plainly retrospective. Finally, point number 6, retrospective retrospectivity of a circular has to be decided on the doctrine of fairness. So Supreme Court noted all these points. Then Supreme Court said what was done by the circular was merely explaining the scope of the notification, accruing to the benefit of the merchant exporters and settling the issue once for all. Circular was issued to resolve the ambiguity in the notifications issued. That is why this circular was issued. Supreme Court held that the substratum of a beneficial legislation is to ensure that the benefit is uniform and absolute, which may be prospective in nature. But when such benefit to one person does not inflict any undue burden on the other, it should be given a retrospective effect. Supreme Court clarified that except in cases where such enactments or issuance of circulars are arbitrary, vexatious, or constitute a parallel mechanism, making its operation unfair, courts need not entertain objections to the operation of a clarificatory or declaratory circular, which is only intended to assert and give effect to its parent provision by statute. This is what Supreme Court said. So, whenever a circular is issued, if it is not arbitrary, vexatious, or constitute a parallel mechanism, then you please give effect. That is what the Supreme Court said. Supreme Court finally held that the circular is clarificatory, curative, and declaratory in nature, and hence it will have retrospective effect. As usual, my comments, you have to bear with me for 2 minutes. One is, circulars issued to remove the ambiguity are becoming more ambiguous. So it creates one more round of litigation. That is the problem with the circulars. One litigation is on the duty drawback. Another litigation is whether circular is prospective or retrospective. So circulars issued to remove ambiguity or becoming ambiguous. That is the point. Recently, Supreme Court in Noble Resources and Trading India Private Limited versus Union of India, I think 2 days, 3 days back, Supreme Court held a circular imposing a new condition and denying the benefit was invalid because notification gave some benefit. Circular added one more condition and denied that benefit. Supreme Court said, no, you cannot add one more condition to the notification, and hence that circular was invalid. That is what Supreme Court said. Second point, I think the circulars can be broadly put into 3 baskets. Circulars represent only the understanding of the department on a particular issue. We all know that. 1. Circular imposing a new condition or contrary to the notification or provision. These types of circulars are clearly invalid because they are contrary to notification. They are only representing the understanding of the department, which is not correct. So they cannot take away what is given by way of a notification or by the act. That is point number 1. I am putting it into 3 broad baskets. Second basket, circular granting benefit more than what is given under the act or notification. Suppose it grants a benefit, okay, you take it. Technically, this is also invalid because you cannot violate the law. Law is clear. If it gives some benefit, you cannot give more benefit than what the law gives. Technically, it is invalid. But since it represents the understanding of the department and the benefits are availed based on that understanding by the assessees, that benefit must be granted to the assessees. One small example I could think of is, suppose if there is a one-way traffic from one A to B. In that one-way traffic, at point B, suppose if the traffic commissioner stands and permits the vehicles to go in the opposite direction. You go. Then he cannot put a police constable in A, point A, and says whatever vehicles are coming on the wrong side, you pay penalty. That is absolutely wrong. Because who permitted it? Commissioner, traffic commissioner himself permitted all the vehicles to go on the wrong side. So how can you put a constable and then say, no, 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 you pay me penalty? That is the way I understand it. So whenever a benefit is given by way of a circular, and the assessees, they have availed that benefit, it cannot be taken away, is my view. Third is circulars in tune with the notification. Suppose whatever the act or the notification says, circular clearly explains it, which is very difficult. I don't know. But there could be a circular which clearly explains what the notification or the act says. If the circular clearly expresses correctly what is stated in the notification or in the act, then it is merely clarificatory. It only explains what is there in the act or the notification. Where is the question of saying it is prospective in nature? That is the point. Because in this case, the department, even though the CBEC, even though it clarified it, they said it is prospective. So where is the question of saying it is prospective? The benefit must be given from the date of the notification or the act. That is the point. Thank you very much. Have a great and wonderful day. Bye.